everyone. Welcome to Taking the Pulse, a healthcare and life sciences video podcast. I am Heather Hoops Matthews here in the studio in Columbia, South Carolina today. We are first joined by Lauren DeMoss, a healthcare attorney in our Birmingham office. Lauren, good to be with you.
Thanks so much, Heather. It's great to be here.
And also in Birmingham, we have a colleague with us today, Brandon Robinson. Brandon, good to have you back.
Nice to be here. Thank you, Heather.
Brandon, you lead the firm's data privacy and cybersecurity team, and I understand that focuses on cybersecurity compliance, privacy issues, and data breach responses, which I know we hate to know happens, but happens a lot. You joined us previously, and we talked about the risk healthcare providers face in this area, and we focused largely on the provider. But I know that the vendors are also a big issue, a big risk point. So today we're going to talk about the different types. And if you could explain the differences and why this part B is necessary.
Sure. Yes. Today we're going to talk about what I think of as the man in the middle. On our last podcast, we talked about healthcare providers and other covered entities and the importance of supply chain risk management from a cyber and privacy perspective for compliance with HIPAA. But we have a lot of clients, and there's a large important part of the ecosystem, which are what we call business associates, which are the service providers to those entities. And as it turns out, they have not only contractual requirements through their agreements with those covered entities, but also direct HIPAA obligations. And they're sometimes in the unique position of being, I call them the man in the middle, because they have to make sure they're complying with their agreements upstream with their customers, the covered entities, but also ensuring compliance downstream with any subcontractors they use. And so it's really a unique position in terms of supply chain and risk management from a cyber and privacy perspective.
Yeah, and I think too, Heather, typically, or I guess historically, your business associate agreements would just talk about the provider, the health plan, the covered entity, and the business associate, and it would have this, provision that was required, but it'd say, and any subcontractors that you use, man in the middle, be sure they agree to the same restrictions that you're agreeing to. And truthfully, that was kind of it for a long time. You had this kind of contractual obligation for the business associate to kind of push down obligations to its vendors. But, and Brandon and I have talked about this a lot, I think that the way the industry has evolved and the desire for multiple parties to have PHI, de-identified PHI, the different kind of levels now of service offerings that are adjacent to or part of the healthcare industry, there's data just being pushed down further and further from the middleman to these third parties, fourth parties, and so on. So the need to kind of ensure that contracts, while they should contain similar, restrictions, but they really need more in them. And at the last podcast, when Brandon and I were talking about healthcare providers, we thought, well, we really need to focus on these kind of middle entities and what's important for them to be thinking about.
It sounds like there might be more of them than the actual provider. Like each provider is going to have multiple vendors.
Absolutely. I mean, I think so. And I think Brandon would agree. There's lots of different levels now of people wanting the information. Companies, from an entrepreneurial spirit, there's lots of companies looking at data. I mean, everything now is so data driven, and especially in the healthcare space, wanting, all the data that you can get to create, look at trends, look at utilization to create potentially AI platforms. So yes, there's more folks in that level, and and they want the information. But the key for the business associate is, if you're going to do that, you need to remember it's really not your information. It's the covered entity or the provider's information. And so you're now kind of a fiduciary of that information. And what do you need to be thinking about if you do have these third parties that are wanting it?
I think generally there's so much more data out there, and there's so much more capability for data analytics out there in the healthcare industry and other industries as well. And so what you find is, in this desire to provide really specialized, custom value add services, it goes in so many more directions, and there's so many services and AI and other platforms that can provide insights and trends and more effective healthcare in some instances. But what that does is it expands the tree of entities that are receiving and processing that information. And so, especially for the business associate who's trying to provide good services to the healthcare entity, who's trying to provide good health services to the patient, it just becomes really complicated and difficult to manage, and thus you need a really robust and organized program to manage that risk.
I heard both of you have used the term business associate, and just in case anybody who's listening to this podcast who is dipping their toe in the water, what exactly does that cover?
Sure. Well, a business associate really refers to any entity or service provider that's collecting, receiving, and processing what we call PHI, which is patient health information. So it wouldn't include, so from the covered entity perspective, it doesn't include their employees necessarily, but it can include any third party entity that's providing services to that healthcare provider or health plan. So that might be a third party administrator that's helping a health plan with claims processing. It might be an accounting firm. We, Maynard Nexsen, as a law firm to healthcare providers, are business associates because we provide legal services that sometimes mean that we need to have access to certain PHI. And that goes for transcriptionists, pharmacy benefits managers, really any entity that's going to receive and have access to patient health information.
Yeah, Heather, and we get questions a lot. I know Brandon and I both have of, and he kind of went through the traditional kind of entities that fit within the role of business associate, but we'll get questions sometimes of, well, am I a business associate? Do I kind of fall under HIPAA, depending on kind of what they're doing and how they're touching the healthcare industry? There's just so many different offerings there. New companies that have cropped up over the last several years that we will get questions of, am I a business associate? And then when we're on the other side, we'll get pushback of, I'm not a business associate. And we're like, but you actually are. You are able to access, see, use, create protected health information. So it's clear. And then in some cases, it's not entirely clear.
Is it a case by case where I could be a business associate in one situation and not in another?
I think it would depend on the nature of the business, Heather, but potentially depending on the company and the type of information they're getting and what they're doing, how they're using it. If it's a data analytics company across multiple industries, the issue then becomes too. I mean, we could go on, but maybe you're getting data from different industries, from not just healthcare providers, but from others that are outside of maybe what we would consider within the realm of HIPAA. But if all that data is on the same platform, or it's in the same cloud, or it's being, put together, and you're mingling it with PHI, then that raises a whole host of other issues. So even if that data is not segregated from everything else, it's still, HIPAA is still going to come into play.
And Lauren, isn't it the case, especially in sort of as we venture into more non-traditional sort of health and wellness aspects, that you may have a company or a family of companies that may be a covered entity in some respects and a business associate in others? Is that right?
That's right. Yes, they can fit within different definitions of HIPAA, and just to layer on even more complication, there are subcontractors. These third parties we're talking about that they're not a covered entity, they're not a business associate, but they're a subcontractor / vendor. But yes, you could have one entity acting in kind of all three capacities, depending on what they're doing and for whom they're providing services.
All right. Well, what if you're one of them and you determine that you're not compliant? What next? What do you do?
Well, and Lauren can provide more detail to this probably, but first of all, we think about your business associate agreement with the covered entity that you're providing services to. So you've got contractual obligations for compliance there in that BAA. But in 2009, under the HITECH Act, which supplemented HIPAA, Congress made business associates directly liable to HIPAA for certain requirements. So a business associate who's not compliant runs the risk, A, of perhaps breaching the BAA that they have in place with their customer, the covered entity, but they also face direct regulation and enforcement from HIPAA for certain requirements that they have as business associates.
Yeah, that's right. I mean, they could, from a non-compliant standpoint, and slightly different than the covered entity, really. The covered entities kind of answer to the Department of Health and Human Services, Office of Civil Rights, HHS, if there's any sort of breach or issue with non-compliance. But in the business associate space, the downstream, they're going to have issues, as Brandon said, with the government, but they're also going to have issues with what they've contractually agreed to with the covered entity, meaning that, they now are in breach of contract potentially. They could have indemnification obligations depending on what happened. So they do, we refer to them as kind of the middleman, but they do have multiple upstream obligations when it comes to how they use and need to protect the information they're getting.
This is for both of you. Couple things. One, what if they are unsure? What steps should they take? And then two, is this something that you're constantly having to review? Because as I listen to you both talk, you're giving dates and saying this has changed and now this is covered, and how do you stay up on this?
I think there's a couple different things that an entity can do to try to ensure they're compliant. I do think it is an iterative process. I mean, as we mentioned, I'll use an example. If one of the business associates' obligations is to be able to disclose upon request, if they have electronic PHI, they've got to give it to the covered entity upon request, and they've got to give it to the patient upon request, right? And so if they fail to do that, they're not only if a business associate fails to disclose that to the covered entity upon request, well, when they ask for that EPHI, they not only run the risk of breaching their contract with the covered entity, but they have potentially violated a regulatory requirement with HIPAA. And so I think if they fail to comply, they may, as Lauren said, they may have indemnification obligations. They may have direct enforcement exposure from OCR. So how do you get your arms around it? I do think there's a couple fundamental high-level things that we'd recommend to sort of manage this process. And they boil down to four things. If you're a business associate, and Lauren, I welcome your thoughts on this too, but I'd say number one, you want to make sure you've got upstream BAAs in place with your customers, the healthcare entities, and ones that you're familiar with, that you've negotiated, that you're comfortable that you can comply with. So number one is upstream BAAs. Number two is have your downstream BAAs with your vendors and your subcontractors that are consistent with the obligations you've agreed to upstream. Number three is making sure you've got the policies and procedures in place internally as an organization that lay out the rules of how you're going to implement these safeguards and these obligations. And number four, having a monitoring and auditing process. Having a due diligence process for those vendors that you sign up with to screen them before you enter into agreements with them. And then also have a mechanism to audit and monitor their compliance with the things that they're contractually required to do for you that you flowed down to them because you have upstream obligations. And that can be a tiered process. I mean, obviously, as the man in the middle, you have budgetary concerns and you've got to do things in a cost-efficient way. But I think having a mechanism where either based on the sensitivity of the PHI or based on the volume of PHI that you're sharing downstream with that vendor, having a way to sort of monitor their compliance to make sure that the documents that you have in place hopefully are being followed. Lauren, any other thoughts on that?
Yeah, I think that's all right, Brandon. One thing I'd add to that too is I think what we sometimes see is you have a business associate that's in that space that's maybe providing kind of some of the typical business associate type services that Brandon mentioned earlier, whether, with billing, with looking at utilization review for the provider. And so you're kind of using PHI, we'll say in the normal course of business when it comes to kind of healthcare entities. And you've got a business associate agreement with the covered entity. Then you're looking at a vendor who wants the information, who may be able to add to, what you're doing, some sort of additional service offering. We oftentimes see a situation where the business associates agreements with the healthcare provider are pretty restrictive when it comes to what else they can do with the information. So can they de-identify it? Well, you may have a business associate agreement with your covered entity that says, or the provider that says, no, you can't de-identify our information unless you ask us. So you may have that sitting out there that you've signed 5, 10, 15 years ago, potentially. And then you now have a vendor who wants to de-identify all the information they're being given and use it for any kind of lawful purpose. Well, if you enter into that agreement with that vendor and it says that, you're now in breach of the agreement with the healthcare provider, the covered entity, that says you need to tell us if someone wants to de-identify information. So being kind of caught in the middle and making sure these stream of agreements actually align and are actually it's permissible what you want to do with any sort of downstream vendor. I think we find business associates that can be a difficult space for them to be in, to make sure, if you have a party saying, we want all your PHI and we're going to de-identify it, so don't worry about it. And you say, great, this looks like a good deal. They're going to, look at it. This will be kind of enhancing our service offerings to the healthcare providers. They're going to run, an additional analytical, on utilization review, and then we can service our customers. Well, your BAA with the hospital may say, or with the healthcare entity may say, you cannot de-identify our information unless you ask us. And so now you've just breached that agreement. So I think that's a very nuanced issue for the middleman, for the service providers in this space.
Complex is an understatement, it feels like, listening to both of you. Finally, how does all of this impact patients? I know people feel very particular about their own information and they don't like it shared, and there are lots of emotions around that. How does all this impact them?
I'd say that, the purpose of these rules, the security rule and the privacy rule within HIPAA, is to securely protect patient health information and the confidentiality thereof. And I'd say, first, the privacy of your personal information is always important to individuals, but the privacy of your health information has always been recognized as particularly sensitive. Because breaches and potential publication of that carry special consequences. I mean, you think about things like HIV status, or a CEO of a company has terminal cancer, and the impact that could have on the company and its shareholders. And so there's special consequences when it comes to health data and the sensitivity of that first. I think second, when it comes to, especially from a cybersecurity data protection perspective, the loss or the alteration of this health-related data. You think if a threat actor were to use a business associate as a backdoor to get into the operational system of a healthcare provider and somehow alter prescription information or have a distributed denial of service attack that shuts down access to patient files at a hospital, right? Those literally have life or death consequences. And then finally, I'd simply say that I think we all recognize that healthcare in this country is really expensive, and anything that makes things less efficient, that compromises the efficient and the quality and the cost of healthcare, has financial consequences to the patient as well. So those are things that come to my mind. But Lauren, you may have other thoughts.
Yeah, I do. No, those are all, I agree with those completely. I think the patients too, these different relationships can be confusing for patients because, we've probably all gotten some sort of flyer or some sort of postcard or, some sort of something in the mail. And we're thinking, who is this entity? What is that? I've never, and it may be that it's an entity that's affiliated with your healthcare provider and they're a business associate, or there's some sort of subcontracted vendor, and the sharing of your information was completely permissible in terms of HIPAA, the uses of it, why they're sharing it, but the patient isn't reading the notice of privacy practices when he or she goes to the doctor to see their provider. And it probably says these are all the entities we share with, and we do share with business associates and vendors, but for the patient to get, solicitations, flyers, information from some third party they've never heard of, that can be confusing to them. So I think informing the patients, making sure authorizations are obtained when it's required. It's not always required, but when it is required, I think that's an important thing for not only providers to be thinking about, but business associates too, depending on what kind of services they're providing.
Well, thank you to both of you for today. This has been a most interesting podcast. Brandon Robinson with the Data Privacy and Cybersecurity Group, Lauren DeMoss, I know my co-host here on Take the Pulse, but also an expert in healthcare law and this specific area. I feel like we could have a part C I know this is part B, but we could have a part C to this. We just thank you both for your time today and your insight and expertise.
Thank you both. Pleasure to be here.
Thank you, Heather.
For those of you who joined us today, we hope you learned a little bit more about data privacy and some cybersecurity issues to at least think about, whether you are the man in the middle, the provider, or way downstream. And we look forward to seeing you next time right here on Taking the Pulse, a healthcare and life sciences video podcast.